Hi, everyone. I'm Jen White, the founder and executive director of Arise. So the purpose of this recording is to either refresh you about how we work our cases or introduce you to our process. So all of our volunteers are vetted. Nearly everyone has pretty significant legal training. And some folks have worked on our cases for a while now, since our founding. But if it's been a while for you, or if you're new to this, I want to walk you through the 6 steps that we go through for our asylum cases. So historically, we have had a dual mission. Arise was founded in late 2022, and we started taking cases in early 2023. So we provide free direct representation to asylum seekers here in Pittsburgh, and then training and mentoring to advocates around the country as we work on our cases. So the idea is that we want people to learn while doing, actually working on cases, or at a minimum, learn while observing as the case is in progress. So I'll be honest, under a Trump administration, this work is really challenging. So historically, under the Biden administration, when we were founded, it was a little easier for us to be intentional about teaching people how to do the different things that you do as you work up an asylum case. But now we're really bogged down with keeping up with all the policy changes, all of the litigation, all of the injunctions, etc. So it's just a little harder for us to be really collaborative, even though that's the spirit of what we do. So because of that, we ask that our volunteers who are eager to learn and contribute would ask questions as we work on our cases. We just don't have the time to provide the level of instruction that we have previously. So please speak up if you have questions, if you need an example from a previously filed case, anything of that nature, please speak up and ask so that we can provide you what you need so you understand this progress and so all of us can grow as advocates. Just because we might not mention something or explain something from the jump doesn't mean that we don't want to. So with that in mind, let me walk you through the 6 steps. So after we take on a case and we assign a team, it's generally led by either a Department of Justice, accredited representative, or myself. Or occasionally we hope in the future to have other lawyers join us as well. So there's usually one person kind of steering the ship because that makes things a little easier. And then there's the 6 parts of the case. So the first part is the client affidavit. The second part is country conditions. Third is evidence collection. Fourth is the brief or legal argument explaining why the person is eligible for asylum. The fifth is the 589, the actual asylum application. And then the 6th is interview preparation. So we provide representation on affirmative asylum cases only, not defensive. So we don't go before the immigration courts, we go before the asylum office in Virginia, because that's where Pittsburgh area clients interview. So I'm just going to give you a super brief overview of all of those 6 steps so that we can dive in as soon as we get the case. And again, please ask questions as you're on these cases and as you're seeing things that are new to you. So the client affidavit. That is the client's story. So we help clients tell their stories in written form so that we're ensuring that they're telling the legally relevant facts of their cases through the affidavits. That process can look really different from client to client. We have a client right now who's a doctor, obviously highly educated, very bright. She's starting residency soon. She wrote her affidavit mostly by herself, and then we helped her edit it. That's kind of one end of the spectrum. On the other end of the spectrum, we have clients who have never been to school a day in their life, and they don't read or write in any language. And usually in that situation, we would sit down and really help them and type out while they talk to us and they explain what happened. So it looks different from person to person. We try to engage our volunteers and let them sit in and watch these meetings with our clients, but sometimes because of significant past trauma or just their preference, they don't want that kind of observation. But we try to make this as accessible as possible because they're great learning experiences. So that's the client affidavit. That's the first part of the case because you really have to understand the story of the client to understand what you then need to gather in terms of evidence and other things. So then we move on to evidence collection, and that can mean so many different things with asylum cases. Because the requirements are so hard to satisfy, and asylum officers really can ask any question about their life, we end up submitting kind of a wide variety of forms of evidence. So evidence can mean a medical evaluation by a psychiatrist, psychologist, doctor, corroborating the past persecution or the mental health effects of the persecution, etc. It can mean an expert academic who provides a country conditions report and explains why this person in particular would be targeted on account of one of the 5 protected grounds in their country. It can include affidavits from witnesses. I could go on and on. Evidence is super broad in these cases. The third step is country conditions research. So we have a video explanation of what this means. If you want to see that, please let me know. We have tons of examples of our tables of contents for country conditions research. But basically what we do is we do a lot of research from a variety of sources, pulling out the unique threats posed in the particular country against our client. And we create a detailed table of contents listing the source and then bullet points from direct quotes from the sources, highlighting the risks on account of the 5 protected grounds. So what we do is we file the actual table of contents and the sources as evidence in support of our case. Fourth part, the brief. The different words for the brief, different synonyms, brief, memorandum, etc. What this is the legal argument explaining why our client is eligible for asylum. I mentioned we only do affirmative asylum. There is an interesting simplification in the affirmative asylum process that does not exist in the defensive asylum process. So I think it's important to keep that in mind. The way we work up our cases is quite different than we would if we were doing removal defense. Our brief is really condensed compared to other types of legal briefs. What we do is we model our briefs after the document that the asylum officer has to submit to their supervisor when they're making a recommendation on a case. So again, we'll go into this in greater detail when we're working on the case, but when you see our very short examples, you might wonder, like, why are these legal arguments so simplistic? Don't we need to be more in depth? The answer is that we're trying to cover the high points, but not provide a really detailed analytical legal argument in support of our case, because the asylum offices don't want that. So we'll explain that more in greater detail. So that's the legal brief. Number 5 is the actual asylum application. If you look up the 589 online, you can see it's like a pretty extensive application in terms of the biographical information that's collected and the substantive legal questions that are asked. So we submit the vast majority of our cases online because it's quicker, faster, easier for everyone involved. So we actually do that 589 online. Last, 6th and final step for clients. Generally, there's always a possibility of like a request for evidence or additional steps we could take, or the client might have to take because of the legal issues presented in that case. But the final step for us in terms of preparation is getting the client ready for their interview. So there's 2 big parts of this 6th and final step. First is giving the client a cheat sheet so they can prepare. So we generally give the client about a half a page worth of information that we want them to cover in their interview. It needs to be short and simple because the effects of trauma really interfere with recall. So we don't want our clients to contradict themselves in an interview compared to what they filed already in their underlying case. So we pull out the most legally salient facts of their story and say, hey, we want you to talk about this in your interview. If they're unable to read or write, we can provide a recording for that, or we can just tell them orally, and as we practice with them, we can remind them of those main points. And the second prong of that 6th step is preparing them for interview by mooting and actually pretending that we're in the interview, playing the role of the officer, having them pretend that they're in the interview and answer the questions. So those are the primary steps. And then, of course, the client is called for an interview, which could be shortly after they submit their application, or it could be many years after they submit their application. So those are the big steps. Let us know if you have questions, and we are so grateful to have you on board in one of our teams. Thank you.